are there any particular triggers for monitoring, such as the repeated restraint of an individual child?
The monitor will be aware from the data that they receive of the name of the child, and it would be my expectation that if there was a child who was particularly prone to restraint, that they would be asking questions in relation to that.
You described meetings between the monitor and senior management staff at the institution. Is the child included in such meetings?
No.
Why not?
Because it's a meeting about the management of the institution, the contract. It ranges across a full range of a wide range of issues about the running of the institution. I can't imagine it would be practical for an individual child to be involved, because it's quite possible in some sense that some of the issues under discussion would affect all the children in the institution, and that is not the way in which we expect our providers to run their SDCs.
Yeah, I just would add that the issues around debriefing is pretty well embedded within the process within STC, so a dialogue would take place with the young person in that respect.
Yes, but I'm slightly at a loss to understand if there is a monitor involved, bearing in mind that young people, even young people with disturbed behaviour, are often much articulate than we imagine, given the chance. Why isn't it routine for a meeting to take place in which the monitor, a member of the senior management, and the young person are involved together, even if subsequently, naturally, there's a management level meeting too?
Well, I think what you're describing there is our approach to debriefing, the approach of our providers to debriefing. That does happen, but the monitor isn't involved in the debrief. It's not part of the specification that we would routinely expect a monitor to be involved in that. And that's as much as anything a workload issue.
So does that mean that the monitor never talks to the young person who's been involved in restraint?
Oh, I was just going to say that as part of the debrief, the young person can request an advocate to be present, and the advocates and monitors do talk frequently.
Is the answer to my question yes, the monitor is never involved, or no, the monitor is never involved in a meeting with the young person concerned? Do you agree with that proposition?
I don't know of, unless either of my colleagues are going to contradict me, of a monitor being involved in a debrief.
Well, it would be helpful if we could have a clear answer to that, because... Sorry, Mr. Hill.
Yeah, sorry, I don't believe it is the case, but I think the role of the monitor to make sure that the quality assurance systems around, making sure all the various issues around complaints, advocacy, all the process kick in if there are issues or concerns around the volume of incidents to do with a particular child. So I think they would oversee to make sure the process takes place, but not necessarily partake in that process.
The other thing perhaps to say is I know you're going to hear evidence from Paul Cook, who's the Director of Children's Services for G4S, who provide 3 and 4 SDCs, and I'm sure his evidence would be illuminating at that point.
Would you like now to comment on Miss James's evidence about litigation, potential litigation? I hope I don't do her a disservice when I say that she says that, for example, disclosure, which is an essential part of all civil litigation and indeed criminal litigation, is not as good in this area as in other comparable civil litigation. In particular, she said that CCTV, which is the real evidence available in some circumstances of events, is never made available. Would you like to comment on those two propositions?
Yeah, I would. I heard the evidence, obviously, and indeed I'm currently in correspondence with Ms Jones about a particular incident, which I'm determined not to simply let slip, but to learn from that. I think I recognise her account of this being a very long and drawn-out process, and we would want it to be as speedy and as facilitative as possible. What I was thinking as I heard her evidence was the pressure that exists on both public servants and private employees not to acknowledge liability for anything that could place either their public enterprise or their private company in some form of jeopardy. It's a sad and regrettable fact that in all the recent roles that I've occupied, both within the YJB but more importantly outside, that lawyers advising me repeatedly say about anything that's going on, for God's sake, don't admit responsibility, don't apologise. It's a bit like the briefing that we get, you know, as motorists from our insurers if we're involved in crime. This is a much more serious matter than that. But it is, I think, part of a much broader public climate around the acknowledgement of liability. But having said all those things, I don't think the sorts of delays that Laura described are as they should be. And my personal commitment is to work with the Hadley to see what we can do to make that process a better one. And so I will, by taking up the particular example of the particular young person concerned, and I've already made arrangements to talk with the provider about that case, as well as to respond to some particular questions that have been put to us by the Hadley.
I've got the flavour of the kind of advice you get from the Government Legal Service, which is a very competent organisation in strict legal terms. What is the attitude of the YJB, if it has an attitude to this, to the possibility of early formal mediation in some of these cases?
It's never been put to me before, and I'm sure when you describe it in those terms, particularly using the word formal, that you have a particular model in mind. We would certainly be very happy to look at that. You know, if this is a large and complex undertaking, the custodial care of children, in which there are, on a daily basis, literally thousands of interactions between care staff, between officer staff and children concerned. It's inevitable, however well we set out our policy, however well we train staff to deliver that, however many checks and balances we build into the system, that a certain proportion of those interactions will not be as they should be. And it's in no part our interest as an organisation, as a reforming organisation, to acquiesce in things that are not working out as they should. So we would respond with keen interest to any proposition that was put to us as to whether there was a better way of dealing with these things. We need, as I said earlier, to take our providers with us in that, and they will no doubt have views on that as well. But I'm putting to you one instinctively, I'm sure will be the position of the board.
Can I ask if there's anyone in the body of the Kirk, as it were, who would like, through me, to raise any questions? Witnesses from the Youth Justice Group? If so, raise a hand. Or for the next few minutes.